Hey everyone, thanks for tuning in today. We're diving into some major news that feels bigger than just one court case or one state. The story of Duncan v. Bonta has been developing for years. And if you follow debates over constitutional rights and firearms law, you probably know how much weight this case carries, if you are new to it. Let me catch you up, because this is one of those legal journeys that actually spills into everyday life. It started back in 2017 when a group of California gun owners and a statewide firearms association decided they had had enough of the state's ban on magazines capable of holding more than 10 rounds. They argued that these magazines are not exotic accessories, but standard parts of millions of commonly owned firearms across the country. And that by banning them, California was stepping squarely on rights guaranteed by the Second Amendment. The case first landed in front of a district court judge who agreed with that view. In fact, his ruling created what Californians still call Freedom Week, a short but unforgettable stretch when people could legally buy standard capacity magazines that had been banned under state law. For that 1 week, gun stores were packed, shipments poured in, and thousands of people bought products that had previously been off limits. But that window slammed shut when higher courts stepped in, and almost immediately the back and forth began, over the years. Duncan v. Bonta bounced between district court, the Ninth Circuit, and even brushed the Supreme Court before being kicked back down. At every stage, the reasoning was scrutinized. Was there a historical basis for banning equipment like this? Did the text of the Second Amendment protect it? And could the state enforce dispossession without offering compensation? Each time the case seemed finished, it revived again. Fast forward to March 2025, and the full Ninth Circuit, sitting en banc, delivered a major blow to the challengers. By a 7-4 vote, the court upheld California's ban and reversed the district court's decision. That opinion leaned heavily on the idea that the state had legitimate reasons to set limits and that the prohibition did not step outside constitutional bounds. It was a turning point, not because it ended the fight, but because it made the next move inevitable. The plaintiffs prepared a petition for the Supreme Court, and just this summer they filed it. The document runs hundreds of pages and it asks the court to weigh in once and for all. At the heart of the petition are two questions. First, whether a state can forbid devices that tens of millions of citizens own and use in lawful ways every day. Second, whether forcing owners to surrender or destroy property they acquired legally, without any compensation, violates the takings clause of the Constitution. These are not small issues. They touch both the right to keep and bear arms and the broader principle that the government cannot simply seize property without paying for it. And because the Supreme Court has already spoken in cases like Heller and Bruin, this petition frames itself as the natural continuation of that line of decisions. Why does this matter outside California? Because the country right now is a patchwork. In some states, the limit is 10 rounds. In others, it is 15. And in some, there is no statutory limit at all. You can cross a state line and shift from lawful to unlawful possession without changing anything about your behavior, simply because a number on paper changes. That inconsistency creates confusion for citizens, for law enforcement, and for courts. If the Supreme Court agrees to hear Duncan, it could replace that patchwork with a single standard, either striking down bans entirely or affirming that states can keep them. Either way, the outcome will echo nationwide. Now it is important to stay realistic. The Supreme Court receives thousands of petitions each year and takes only a small fraction. Still, the issue raised here is pressing, and justices like Kavanaugh have already hinted that the court will eventually need to take a magazine ban case. The timing, the posture, and the depth of the record all make Duncan a strong candidate. For now, the petition is in, the debate is sharpened, and the next move belongs to the highest court in the land. When a case climbs this high in the judicial system, the story is never just about one statute or one state. It becomes a reflection of how the Constitution itself is read, argued, and applied. Duncan v. Bonta has reached that level. The Ninth Circuit's decision earlier this year to uphold California's ban was not just a regional ruling. It set the stage for a confrontation between two competing visions of the Second Amendment, one that emphasizes limits as a matter of public safety, and another that insists common ownership defines protection. That clash is what makes this petition to the Supreme Court so consequential. The Ninth Circuit opinion was written in confident terms, but the dissenting judges made it clear they saw the ruling as incompatible with recent Supreme Court precedent. Their arguments pointed out that in the Bruin decision, the court demanded a historical test, If a regulation touches the right to keep and bear arms, the government must justify it with a tradition of similar laws from the founding era. California, they argued, could not find such analogs. Instead, the state leaned on modern policy arguments, essentially saying that capacity restrictions reduce harm in certain types of crimes. The dissent stressed that this was exactly the sort of interest balancing the Supreme Court had already rejected. That tension is now sitting at the heart of the petition, and it gives the justices a clean chance to clarify how far the historical test reaches. The petition also takes time to highlight the way California shifted its grandfather clause. For years, individuals who had purchased magazines before the ban were allowed to keep them. Later, that allowance was pulled back, and owners were required to destroy, surrender, or export their property. No compensation was offered, which raised the question of whether such a move counts as a taking under the Fifth Amendment. If the court decides to address that second issue, it could have implications far beyond firearms, reaching into how states handle all kinds of property restrictions. From a national perspective, the timing could not be more significant. Across the United States, lawmakers have experimented with different capacity limits: 10 rounds in one state, 15 in another, 20 in a third. These numbers are rarely tied to historical practices. They are chosen as political compromises or as symbolic statements about balancing rights and safety. For ordinary people, the result is confusion. Travelers who drive from state to state cannot be sure whether their equipment is lawful. Retailers and manufacturers face a fractured market, and police officers encounter citizens who may not even realize they are breaking the law because they crossed an invisible line on the highway. The Supreme Court has often stepped in when constitutional rights are treated so differently depending on geography. The Second Amendment has proven no exception, with cases like Heller and McDonald ensuring that the right to keep and bear arms is treated as an individual right, enforceable against state and federal governments alike. Bruin then added the history and tradition requirement. Now Duncan asks whether those principles extend fully to magazines, which function not as accessories but as essential components of modern firearms. Some observers believe the court is ready to resolve the question. Others caution that the justices may wait for another circuit to split with the Ninth before stepping in. The truth is, no one outside the court can predict with certainty. What is clear is that the issue will not disappear. With millions of magazines already owned nationwide and states continuing to legislate in different directions, the question will return until the justices eventually accept it. That persistence alone underscores why this petition is worth watching. For people invested in the outcome, patience is necessary. The Supreme Court operates on its own timetable. Conferences to consider petitions begin in the fall. The justices review submissions privately, debate which cases warrant their attention, and vote. Sometimes they grant review, sometimes they deny without comment, and sometimes they hold petitions while waiting for related cases to develop. Duncan now joins that queue, and the earliest indications of its fate will arrive when the justices issue their orders lists later in the year. Until then, advocates on both sides will prepare, commentators will speculate, and ordinary citizens will continue living under the patchwork of current laws. However this unfolds, the importance of Duncan cannot be overstated. It has traveled a long road already, from district court to appellate reversal, from Freedom Week to en banc review, and now into the shadow of the Supreme Court. Each twist has reshaped the debate. Each ruling has inspired both optimism and frustration, and each development has carried lessons about how fragile or durable rights can appear when tested in court. The next step will either solidify the Ninth Circuit's view or open the door to a nationwide standard. Either outcome will mark a turning point, not only for California but for the entire country. Whenever a case reaches the Supreme Court, the sense of anticipation always grows, and Duncan v. Bonta is no exception. What makes it unique is the combination of factors: years of litigation, multiple dramatic reversals, the short but unforgettable Freedom Week in California, the detailed petition now filed, and the undeniable national implications. Every step has created a sense of momentum that feels like it can only be resolved at the highest level. Whether the court agrees to take it now or waits for another day, the story of this case has already changed how people talk about magazine limits, about the Second Amendment, and about the relationship between state authority and individual rights. For many observers, the most striking part of this saga is how ordinary people have been swept up in its tide. Imagine being told one year that something you bought legally and used responsibly is fine, only to be told later that you must surrender it or face criminal consequences. That back and forth creates uncertainty and erodes confidence in the fairness of the law. It is not simply a technical debate between lawyers. It affects families, hobbyists, competitors, and even police officers who rely on standard equipment. That human side of the case often gets overshadowed, but it is worth remembering because it explains why emotions run so high whenever Duncan appears in the headlines. As for what comes next, it is impossible to predict. The Supreme Court may grant review and schedule arguments that could reshape firearms law for decades. It may decline, leaving the Ninth Circuit's ruling as the controlling precedent in the Western states. While other regions continue experimenting with different limits, it may even hold the case temporarily while watching related litigation develop in other circuits. Each option carries consequences, and each outcome will spark debate. Regardless, the questions presented will not disappear. They are too central, too deeply tied to the structure of constitutional interpretation, and too closely connected to everyday practices. When looking at the broader pattern, one thing is clear. The Supreme Court has consistently reinforced that rights listed in the Constitution deserve full respect. At the same time, the court has left room for historical tradition to guide where lines are drawn. Duncan asks the justices to apply that same logic to magazine bans, which so far have been justified more by modern policy preferences than by examples from the nation's founding. If the court agrees that such bans lack historical support, the ripple effects will be immediate. If it does not, states will be emboldened to pursue even stricter restrictions. Either way, the decision will clarify the scope of the Second Amendment in ways that everyone will feel. So, as we wrap up this discussion, I want to hear from you. Do you believe the Supreme Court will agree to take Duncan v. Bonta this term? Do you think magazine bans can survive the historical test laid out in Bruin, or do you see them as destined to fall when examined closely? Drop your thoughts in the comments. Share how this affects you in your state. And let's get a real conversation going. The more perspectives, the better. Because this case is about more than just legal theory. It is about how laws shape real lives. Thanks for watching, thanks for engaging, and stay tuned because whatever happens next, it is going to matter.